the participants of the JCJ 2022 main examination. The examination is going to be held on 26 November 2022 if it is not postponed. Participants, anyone can unmute and read that what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen. Are you hearing me? Okay, I may read it. Welcome to the aspirants of JCJ 2020 main examination on 23rd November 2022. And today deliberations on the basics of the law of evidence hosted by the Professor Dr. Mohammed Saheb Hussain, Professor of Class South, Postbox 307, Mwanza, Tanzania, East Africa, mobile number 752936100. Yes, without wasting the time, let me go to what is the basics of the law of evidence. But before I could give it, I should be very much thankful to the article written by the Sparsh Mali, the fourth-year students of the School of that is the University of Petroleum and Energy Studies, Dehradun, India. So now let us see what is the introduction of the basic of the law of evidence. The law of evidence is a significant part of any branch of the judicial system, irrespective of any nation, which means the role of evidence is very important statute in every country. Without the evidence, the relevancy and not relevancy, whether taken into consideration, the facts and proofs, it will be depend upon the cases, and without the evidence, it cannot be, a true decision will be taken. But taking specifically about India, the enactment of the Indian Evidence Act has changed our judicial system completely, as there were no codified law relating to the evidence, which enriched our judicial system by providing the rules and regulations for ascertaining the shreds of the evidence. So it is codified, and that will help you to see the examination in chief, cross-examination and re-examination, and evidentiary values, what could be proved, dying declarations, many other things are there which will be helpful in extracting the truth from the evidences or from the records. Although the Indian Evidence Act is based on English law, still it is not fully comprehensive, and also it is a lex fori. That is a law which means the law of the land, a law of the forum where court proceedings are taken. The term evidence is derived from the Latin word ei, that is exemplification. No, ei means it has stay. That is evident, 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 or evidere, evidere, which means to show clearly, or to discover, or to ascertain, or to prove. These are all the synonyms should be there. To show clearly, number one. Number two, to discover. Number three, to ascertain. Number four, to prove. That is the evident, evidere. So it is the etymology is derived from the Latin terminology. Okay, welcome to the Veruna that we are dealing the basic of the law of evidence today in the class. The Evidence Act came into the force from the 1st September 1872, applies to all over the India except the state of Jammu and Kashmir. I believe that when the 370 is scrapped over there, I believe that this provision may not be applicable, if I not be mistaken. The limitation of this act does not end here. It is not applicable to army and naval law, disciplinary acts, and all the affidavits. It is well known that the law of evidence is a procedural law, and it only applies to court proceedings, but also a future it is some of the parts make it a substantial law, like a doctrine of estoppel. So now, Sir Venunath, can we say that the law of evidence is the procedural law or substantial law? I believe that you are hearing me.
Law of evidence is a procedure law.
And some of the parties also substantial law. For instance, you take the doctrine of estoppel.
That is there, but mostly it is a procedure, na? Because
mostly procedure, but there is another word also you can use it. Instead of saying the procedural law and substantial law, we can say the adjunctive law. ADGUNCTIVE.
Adjunctive law.
Yes. It is a specific because it is a blended of the two. Procedural plus substantial. So now let us proceed. The primary objective of any judicial system, irrespective of any state, is to administer justice and protect the rights of the citizens. For administrating justice, every judicial system has to consider the facts of the cases and has to extract the correct facts for complete justice. And there are importance of the procedural law comes into the existence, which laws different rules in checking the values of the facts produced by the law offender and by the victim. So, adducing the exact facts, we can employ the law of evidence to get a justice, to administer justice. I believe it is about the civil as well as the criminal matters are concerned. The complete corpus juris, it has to, means that is a body of law, is divided into two categories. Number one, substantial law, which means a set of rules and regulations that govern the society. Number two, adjective laws. There are the set of rules and regulations which deals with the law governing the procedural aspects such as the evidencing, pleading, etc. So the two categories are to be there. That's why we can say law of evidence is about the substantial law and procedural law. And generally we say adjective law or adjunctive law. In the adjective law, there is a set of rules are there which will help to administer the justice, especially in the matter of the evidencing and pleading, etc. But the law of evidence neither comes under the substantial law nor the under procedural law, rather it is a subject matter of the adjective law. Adjunctive law or adjective law, ADJUNCTIVELU. ADJUNCTIVELE. Okay, here the adjective law, which defines the pleading, evidencing, and procedure with respect to the substantial laws. The general meaning of the evidence is a body of the facts and information indicating or educating the values of any fact or evidence. So let us see adjective law, adjunctive law. ADJNTIVE. Adjunctive law is law of evidence or adjective law. Adjective law covers the law of evidence, civil procedures and criminal procedures. These are called said to be the adjective laws. Difference and distinctions substantial law. The rules of substantial law define the rights and duties of the person in their ordinary relationship of each other. Adjective law is accessory to the substantive law. So if the substantial law, adjective law is accessory to the substantive law, and that's why we can, if you say so, even the civil procedure code and the criminal procedure code and law of evidence, all three will come under adjective law because it will accessory to the substantive law. Am I right?
Yes, sir.
So more better to say adjective law, ADGECTIVIL. So instead of saying adjunctive professor means a part-time professor. Are you following me?
Yes, yes.
Are you a visiting professor? So let us see the classification now. Evidence is classified into different categories such as oral evidence. Section 60 deals with the oral evidence, where oral evidence is those evidence which is witness has either personally seen or heard any such facts or information which has the capability of proving or establishing the facts in issues. The only condition with these types of evidence is that they must be direct or positive for establishing the fact in issues. What about the hearsay evidence? I'm sure that it's also oral evidence. With the
Hearsay evidence
is
is
admissible.
not an evidence. Actually, it is not admissible in most of the cases.
Okay.
Because it's when two people are talking something, the third party overheard that incident.
Okay.
So how can a third party give evidence against some other person whom it does not even know, not seen?
The consequences, subject matter, or context.
Yes, yes. Because if X has committed a crime,
Okay.
Y and Z were talking about that crime,
Okay.
and A listens to that
Okay.
somehow by walking or by some way standing somewhere, he listens to that. Now, here's evidence is that पहला वो दो YZ जो बात कर रहे हो कितना सच है भगवान जाने,
Okay.
और ए आके और मिर्च मसाला ऐड करेगा, उसमें कुछ ओमिट करेगा, he'll add his own sentences,
And he interpreted his own way of interpretation.
his own thing. Yes, इसलिए most of the cases here's evidence is not treated as evidence, but unless अगर कुछ है ही नहीं है तो then they might consider.
Okay. So can we say the corroborative evidence?
No, corroborative evidence is when what you are saying and what is there in the records, whether it's matching, then it's called corroborative evidence.
Okay. Means
It's matching with each other.
yeah. Means compactness would be there.
Yes.
Okay. So second one is documentary evidence. Section 3 talks about the documentary evidence where those facts or information in the form of the document can be witnessed directly by the court of law for establishing the fact in issues. Now the compact disc film, can we count it as a documentary evidence?
Yes, those are documentary evidence.
And primary evidence, section 62 deals with the primary evidence. These are those facts or information which by any means has a great capability of proving or disproving any fact in issues. Then such information is considered as a primary evidence, like a paper document of any vehicle, means registration, or primary evidence to prove the ownership of the vehicle. Then
Example.
title deed also.
Yes. Example अगर मान लीजिए,
Okay.
अगर एक फेमस रॉक है, उसको पर कुछ स्कल्पचर्स किया है, अभी वो रॉक को तो कोर्ट तक तो नहीं लेके आ सकते.
Yeah, that is true.
So what we do, then we take picture and we bring that picture to the court and we say this is the original evidence.
Okay. So
because you cannot, certain things which you cannot bring to the court, but they exist really.
Yeah. Then it can be, even photos can be taken as a primary evidence.
Yeah, photos में क्या होता है nowadays, पहले तो क्या negative होता था.
Okay.
अभी photos में क्या होता है, now this mobile everything coming into picture.
Even they take the video also.
हाँ सर.
They can take the video also.
हाँ, वीडियो लेके आ सकते हैं, लेकिन क्या होता है, whenever you taking out any picture through a mobile,
Okay.
so you should install one separate app which shows the date, time, longitude and latitude.
Okay, that means everything will be recorded. Geographical indication also there.
Yes. नहीं तो क्या होगा मालूम, पता नहीं आपने कब निकाला फोटो, वो आज प्रोड्यूस कर रहे हो.
Okay. It will record even minute also, how much minutes and at what time it started, what time it ended, where is the place and everything.
So what अभी क्या कर, most of the people अगर कुछ वीडियो बनाने का है, तो क्या करते हैं, उस दिन का न्यूज़पेपर लेके हाथ में
अच्छा
रखते हैं. समझिए आप, उस दिन का न्यूज़पेपर लेके हाथ में रखते हैं, पहले न्यूज़पेपर में दिखाते हैं कैमरा में, बोल्ड में, देखो आज तारीख की न्यूज़पेपर में ये लिखा है, आज टुडेज डेट, और आज मैं इधर वीडियो कर रहा हूँ ये इंसिडेंट में, तो दैट बिकम्स ऑथेंटिक कि दिस वीडियो हैज बीन रिकॉर्डेड ऑन दैट डे ओनली.
Right. So shall I proceed to the secondary evidence?
Yes.
So secondary evidence, section 63 deals with the secondary evidence. These are those evidence which is given in the absence of primary evidence. Like when there is no primary evidence, then secondary evidence can be used to prove the fact in issue.
Yes.
Example, if the original paper document is lost, then its photocopies can be used as a secondary evidence to prove the ownership.
Yes. Even now that also is accepted. अगर आपके पास ओरिजिनल नहीं है,
Scanned copies.
All scanned copies of copies are now recognized.
So it is a count as a secondary evidence.
It's called a secondary evidence. You have to if you don't have a primary evidence, then you have to make an application to the court stating that the primary evidence has been lost, misplaced, destroyed, whatever it is that. Now you are placing a secondary evidence before the court. Well, the court will consider that as a secondary evidence.
Okay.
And that will take into evidence part.
Okay. That means the secondary evidence should be taken as a primary evidence in place of it.
Yes, yes. But with the permission of court.
Yeah. So real evidence. A real evidence means material evidence where the court can inspect the evidence directly and requires no further knowledge. So primary evidence is a real evidence.
नहीं, इसमें क्या होता है? Real evidence, direct evidence. In real evidence is that आपके पास एक मूर्ति है.
Okay.
जो 500 साल पुराना है.
Okay.
तो आपके पास भी एक पेपर भी रहेगा 500 साल पुराना बोल के.
Yeah.
तो वो पेपर देख के तो नहीं बोल सकते ना कि यही मूर्ति है बोल के. तो मूर्ति के साथ मूर्ति को भी लेके आना पड़ेगा. देखो ये मूर्ति है, उसका पेपर ये है. मतलब that is real evidence.
Okay.
वो मूर्ति देखा कोर्ट ने. And there'll be, अगर मान ले पेपर भी नहीं है आपके पास उसके बारे में. अभी 500 साल पुराना कौन पेपर रखता? 500 साल पुराना वाला.
Yes.
So you'll have some historians, you'll have all this, some people.
They will measure it. They will gauge it, how much old it is.
उसका स्कैनर रहता है उनके पास.
Yeah.
वो स्कैनर से बताता हो कितना साल पुराना है बोल के. Then that expert will tell in the court, हाँ ये जो मूर्ति है जो भी है, this is original. That is real evidence.
Okay. So direct evidence. It is one of the most powerful type of evidence as the court need not make any inference because this evidence shows the direct impact has a great value to establish or to prove any fact in the issues. Direct evidence.
Direct evidence मतलब अगर मेरे सामने किसी का खून हुआ है.
Okay.
और मैंने खून को देखा. I've seen that person killing the other person.
Now we can say eyewitness. So directly he has seen it and he is so-and-so person murdered so-and-so person with the instrument at the so-and-so time. So now let us see the indirect or circumstantial evidence. When there is no sufficient direct evidence to prove any fact in issue, then the court can make an assumption on the availability of the existing evidence and construct a link between the existing evidence and the inference. And if the constructive link is completely beyond any reasonable doubt, then the court can establish any fact.
Yes.
Means supporting.
इसमें क्या होता है? हाँ, इसमें क्या होता है? Not supporting. इसमें क्या होता है कि अगर मान ले किसी एक आदमी का मर्डर हुआ है.
Okay.
कोई जंगल में हुआ है.
Okay.
आज की तारीख में क्या है? टेक्नोलॉजी इतना बढ़ गया है.
Yeah.
कि अगर मैं मोबाइल लेके वो जंगल में से जा रहा मैं.
Yeah, that directly can shoot it.
तो अगर मान ले नहीं शूट करने की जरूरत ही नहीं है. अगर मैं मोबाइल लेके गया मेरे पॉकेट में, मैं किसी और को गुस्से में आके मार दिया मैंने.
Okay.
मैं घर आ गया मैं.
Okay.
तो पुलिस तो ढूंढते रहेंगे कौन मारा बोल के.
Yeah.
Then what they do? फिर वो कॉल डेटा निकालेंगे. अरे that's called dump data. Dump.
Okay.
तो देखते अरे ये बंदा आया, इसका दुश्मनी कुछ है क्या हुआ. So that is called circumstantial evidence. लेकिन उनके पास कोई direct evidence नहीं है that I have killed. But your mobile is showing that you were there at that point of time, and the forensic report says that this person was killed on so and so time roughly.
Okay.
इसमें क्या होता है? डायरेक्ट ये होता है कि भाई हाँ तुमने indirectly मतलब circumstantially shows that you have killed that person बोल के.
And even the blood stains or the weapon used over there is found near the bush.
सर वो वेपन यूज किया है, ब्लड स्टेन. अभी मान ले मैंने चाकू लेके भोग दिया, चाकू मेरे साथ ही लेके गए जंगल कहीं 50 किलोमीटर का नदी में फेंक दिया. कहाँ से मिलेगा पुलिस को?
Yeah, because they could not make it out. Definitely, he might have to buried also.
You cannot even find also. तो उस टाइम पर कि circumstantial कौन they take all the dump data कौन क्या है, कौन सा गाड़ी गुजर गया, वो सब निकाल के देख के then this okay.
Yes,
ये बंदा गया.
That will be there. Definitely, it will be make it out. So with that, we can make it out. It is a circumstantial evidence, and the circumstantial evidence will be taken into consideration at the time, isn't it?
Yes.
So that was the thing we have to make it out. Now let us see the hearsay evidence. In the hearsay evidence, here evidence is a very weak evidence or no evidence as to the witnesses. Himself is not the actual witnesses of the act in issue, because whenever he is reporting is not what he saw or heard, rather the reporting the facts which are narrated by another person. And hence the court believes that the narrated facts by the third person have not much credibility in establishing any fact, because he doesn't know in which context they are discussing and they are making and they are doing the things are concerned, and that is the reason that they cannot make it out. So that is the hearsay evidence. So as you say, when the two persons are making the conversation each other, but a third person heard it and is giving the evidence, that's said to be the evidence, hearsay evidence. Yes. So now let us see what is the judicial evidence. The judicial evidence, statements of the witnesses, documentary evidence, facts established during the examination of a witness in a court. Self-incrimination is some kind of the evidence which the court receives, where the court receives, court receives itself, and such evidence are known as judicial evidence. Can you elaborate this judicial evidence?
Judicial evidence, all those evidences which are given in the court, क्रॉस एग्जामिन किया होगा या कोर्ट में आपने कुछ डॉक्यूमेंट प्रोड्यूस किया होगा. हेलो,
व्हाट इज सेल्फ इंक्रिमिनेशन?
No, self incrimination, the constitution provides you cannot be a witness in your own statement, in your own case.
Okay.
That is confession. When you make your own this thing, that is confession.
Okay. So examination of witness is the court which gathers over there the evidence that is said to be the judicial evidence.
Yes.
Non-judicial evidence, confession made with the witnesses or accused or victim outside the court are considered as a non-judicial evidences.
जैसे एक्स्ट्राऑर्डिनरी पुलिस का रहता है, पुलिस में बोलते ना, पुलिस के सामने आके कोई आके गवाह दे दिया. Well, that is not valid unless that person comes and says in the court, then only that it's called judicial evidence. पुलिस को आके गवाह देने से उसको.
What is 161 statement? Is it the police recording statement is the 161 statement?
That is extrajudicial confession, extrajudicial statement.
Okay. Now let us see what is the prima facie evidence. The concept on the face of it with respect to evidence is a principle when the court presumes any fact and consider them proved until they are disproved. Then such evidence is known as the prima facie evidence. So unless it is disproved, it is taken as a prima facie evidence.
तो आप देखिए जब भी कुछ केसेस होता है या मनी लॉन्ड्रिंग केसेस होता है, जीएसटी का केसेस होता है, सो पहला ये पुलिस वाले हो जो भी हो एफआईआर लिख के चार्जशीट फाइल कर देते.
ओके.
कि उसमें आफ्टर सीइंग द रिकॉर्ड्स, आफ्टर सीइंग एवरीथिंग, कोर्ट presumes that there is some evidence against this person. Presumes. It is not courts come to it. That's on the court will only decide after conducting the trial.
Okay.
तो क्या करेगी, इसको पुलिस कस्टडी देगा या जुडिशियल कस्टडी में भेज देगा उसको.
Okay.
That presume is called prima facie.
Right. So the need for the evidence law. Evidence is the only possible way by which the court can make an inferences render decision. The definition of the evidence explains that the evidence is the proof of any fact in issues. So without evidence, there will be no possibility to prove any fact in issues or even to establish any fact in the cases. It is very obvious that it is not much difficult task to obtain trust through the violating the basic structure of the law, but in the course of the protecting those rights, evidence law comes into the picture. So evidence tells the basic principles and rules regarding collection, either in the form of the document or in the form of the witnesses or in the form of the evidentiary values, judiciary evidence. By any other means, if they will come to a conclusion and extract extract the things from the facts. So the process of evidencing any fact or proof should be governed by the well-established law in order to achieve the speedy and fair justice. So the law of evidence is not just a fundamental principle governing the process of proof, rather it also a multi-dimensional purpose for governing the rules relating to the process of the proof in court proceedings. While its moral dimension is a special asset in criminal trials as it endures in protecting the innocent and highlighting the guilty person to administer complete and fair justice. On the other hand, the evidence rules also have the capability to hide and prevent the truth to be disclosed in public domain to protect the mass public interest. What is this? This last line.
पूरा बड़ा के जैसा नहीं दिख रहा है मेरे को.
Is it not visible?
I am not visible because आपने 40% किया इसको. हाँ.
What about now?
नहीं अभी नहीं वो पहले वाला.
Here. I increase the font. Yeah. Now, which I highlighted.
Yeah. On the other hand, the evidence rules also have the capability to hide and prevent the truth to be disclosed in the public domain to protect the mass public. मतलब कुछ चीज ऐसा रहता है जो पब्लिक डोमेन में आना नहीं चाहिए. एविडेंसेस. एग्जाम्पल सेक्सुअल हरासमेंट है.
Okay.
Witnesses are not supposed to be disclosed to the public.
Okay.
Even the party's name, rape, जहाँ पे रेप हुआ किसी लड़की का है.
Yeah.
Even the name of the party is also not supposed. Identity of the victim also is not supposed to come in public domain.
And that is the reason that the Delhi case
In-camera
is
proceedings होते हैं.
Nirbhaya case la.
निर्भया तो that was the starting point. निर्भया. उसके
Okay.
बाद बहुत सारे केसेस हुआ है. सेक्सुअल हरासमेंट केसेस हो कुछ भी हो. पॉस्को, even in POXO also.
Okay.
हाँ.
The parties will not be revealed.
Yes. Only those parties. ऑपोजिट पार्टी का भी अगर कोर्ट सोचता है कि ऑपोजिट पार्टी का वकील को भी नहीं बिठाना है, दे विल नॉट इवन एंटरटेन हिम इन द कोर्ट.
Okay.
Only the child, his parents, his or her parents, बच्चे का प्लस उनका वकील.
And we can say the camera proceedings.
Yes. Completely in camera proceedings.
Okay.
That happens in all the courts, including High Court and Supreme Court.
Very good.
And other thing is that if police wants to meet any of the child, child, he should not be in police uniform. He should be in civil uniform.
Okay.
That is a mandatory rule.
So now basic legal terms are concerned. Fact in issues. Section 3 of the Indian Evidence Act defines fact and fact in issue in such a way that facts means the happening or existence of anything. These are particularly knowledge or any information related to anything. Whereas facts in issue are those facts which are in question or those facts which need to be proved for the purpose of ascertaining some information and making the inferences out of the relevant information in the case in obtaining the justice. So fact in issues. Illustration.
Facts are true. ठीक है आनंद.
A is the owner of a shop.
It's a fact.
A is accused of robbery. Now whether A committed a robbery or not is a fact in issue.
खुद का दुकान में चोरी किया क्या उसने, वो इश्यू है.
Yes. Or he burnt his house on himself and want to claim the insurance.
Yes.
So fact is house is burnt. Whether he himself burnt or somebody is burnt.
That is the issue.
That is the fact in issue.
Yes.
So now relevant fact. The actual meaning of relevant is connected. So those facts which give any inferences or support or influence to any other facts, then these facts are known as relevant facts.
एग्जाम्पल अभी इसका ही ले लीजिए.
Yes.
ए का दुकान है.
Yeah.
शाम को जाता वक्त ए ने क्या किया, केरोसिन खरीद के लेके गया और दुकान में डाल दिया.
Yes.
और आग लग गया.
Yes.
रात को. तो कनेक्ट रिलेवेंट फैक्ट है, शाम को इसने केरोसिन खरीदा है और
Yes.
दुकान में रखा है.
Yes. That is a relevant fact. Eh?
Yes.
So here illustration also given. A is accused of murder of B in Agra. It is a fact. A was in Canada for his business meeting at the time of the murder. Is a relevant
It's a
fact.
relevant fact.
Is
Then
it
he'll claim alibi, he'll claim.
alibi?
Alibi he'll claim here.
ALIBI.
Yeah, ALIBI.
So a relevant fact is at the time of the incident he was no more there.
Hmm.
Or he is taking the bedridden in the hospital undergoing the treatment.
Hmm.
So that is a relevant fact.
Yes.
Okay. Proved. A fact is considered to be proved when the court, after considering all the defenses after the trials and proceedings, either believes the happening of the case in such a manner it is expressed, or if the court makes a probable inference beyond a reasonable doubt and believes that the existence of the case in such manner as it was explained. That means the court will be fully satisfied by the proceedings and by the trials that the manner it is expressed in the court is probable inference, and hence there is no doubt at all. Beyond the reasonable doubt, it believes such a thing is proved. Disproved. A fact is considered to be disproved when the court, after considering all the evidence after the trial and proceedings, either believe it does not exist as explained, or if the court makes a probable inference beyond the reasonable doubt and does not believe that the existence of case such a manner as it was explained. So that is said to be the disproved. The facts proved, the fact disproved. So proving is the burden on the person who wants to prove that what he says is true,
Yes.
or what his claim is right. If he fails to do so, that means he disproved what he wants to prove.
There is no difference between proved and disproved. अगर प्रूव हुआ तो प्रूव्ड हुआ, नहीं हुआ तो डिस्प्रूव्ड हुआ. And you read the sentence of proved and you read the sentence of disproved, एक ही है.
Yeah, only the thing is believed proceedings, trials, believing it not, then it is disproved.
Yes.
See, beyond a reasonable doubt and believes that. Here, beyond the reasonable doubt, does not believe that.
वही बोलूं ना.
Here, does not believe that, only that thing. So, that is a proved and disproved.
Example कोई बोलेगा,
Yeah,
a person who is handicapped,
yeah,
who cannot walk with the help of a stick, और किस हैंडीकैप में क्या किसी का हाथ पैर कुछ ना कुछ डिफेक्टिव होता है.
yeah.
Someone comes and says, सर इसने लड़की को भगा के लेके गया और लड़की के साथ भागा. अरे बोला, कोर्ट खुद बोलेगा, साला तू फिजिकली हैंडीकैप लड़का वो लड़की के लिए से कैसे भागेगा रे, बता रे बोलेगा.
Yes, naturally.
बात को कोर्ट खुद बोलेगा, उसका शक्ल देखा, उसको चलने के लिए ही तकलीफ हो रहा है, दौड़ेगा लड़की के लेके, क्या बोलेगा.
How could he carry away and run away?
तो ऐसा होता है.
Not proved. A fact is called not proved when the facts are in a circumstance and condition that are neither proved nor they are disproved. या प्रूव भी नहीं कर सकता ना डिस्प्रूव भी नहीं कर सकता.
डिस्प्रूव नहीं कर सकता. कैसा होता ना, सब मर्डर हुआ है लेकिन ये आदमी है या दूसरा आदमी है मुझे पता नहीं बोलेगा.
मर्डर तो हुआ,
मर्डर तो हुआ लेकिन शक्ल तो मिलता है, लेकिन यही आदमी है क्या मुझे पता नहीं सर बोलेगा. हो गया अभी नॉट प्रूव्ड.
Either proved or not disproved. It means it's not proved.
Yes.
Presumption. Presumption generally means a process of ascertaining few facts on the basis of the possibility, or it is the consequence of some acts in general which strengthen the possibility. When such possibility has great substantiate value, then generally facts can be ascertained. A presumption in law means inferences which are concluded by the court with respect to the existence of certain facts. The inferences can either be affirmative or negative, drawn from the circumstances by using the process of the best probable reasoning of such circumstances. So the basic rule of the presumption is when one fact of the case or circumstances are considered as the primary fact, and if they are proving the other facts related to it, then the facts can be presumed, and if they are not, they are proved until disproved. They are proved until disproved. वही बोलते ना, in the criminal law you can say accused only till he will be guilty, then we can say convict. Up to that extent you can treat him as a accused. Section 114 Indian Evidence Act specifically deals with the concept that the court may presume the existence of any fact which things likely to have happened, regard being had to be common course of a natural event, a human conduct, c. public and private business, in either relation to the facts of the particular case. So, presumption, if a man could not be heard consecutively more than 7 years, the presumption is that he is no more. Am I right? Neruna,
Yes, sir. Yes, sir.
what is the presumption? If a person could not be heard consecutively for the 7 years, his presumption is he is no more, means dead.
Dead. But subject to filing case, filing a missing complaint.
Subject to?
Filing a missing complaint, from that day it is treated as 7 years.
Okay.
ऐसे नहीं कि वो 7 साल चले गया तो मर गया बोल के नहीं, पुलिस को इन्फॉर्म करना पड़ेगा कि भाई ये तारीख से ये बंदा मिसिंग है, तो उस तारीख से जिस दिन से वो कंप्लेन लिखा है, एफआईआर लिखा है, जो भी लिखा है, उस तारीख से 7 साल तक इट इज कंसिडर्ड. And police will not give that missing as dead. Then you have to apply to the court.
Sir, we gave the complaint to the police on the so-and-so date. 7 years are crossed, but his whereabouts are not known and heard.
Yeah, but police will give the report. We have searched everywhere. We have not found him. So, वो लिख के देगा. Then court will decide. चलो ठीक है, we are declaring dead बोल के.
The police will write after 7 years?
Yes. अगर मान ले 5वें साल में लिख के दे दिया, पता लग गया 6 साल में आ गया, कैसे होगा?
That is not the presumption that he is dead.
हाँ, इसलिए 7 साल तक रुकते हो लोग.
Okay.
7 साल से ज्यादा रुकते हो लोग.
Okay.
7 साल और 8 साल रुकते, फिर बाद में लिख के देते, भाई देखो जाओ. Then they'll not give. They'll give. You have to make an application to the court. फिर court will ask the police to give its report. फिर वो लोग court को report देंगे. Then the court will decide.
Yes, he is presumed to be dead.
हाँ, फिर कोर्ट पूछता है इसके ऊपर क्या क्या एसेट्स है, क्या लायबिलिटीज है, कितना कुछ इंश्योरेंस है, क्या सब डिटेल्स लेके देन द कोर्ट विल से ओके ही इज प्रिज्यूम्ड टू बी डेड नाउ.
Then the legal heirs will be the heirs.
Then court will give death certificate, not the municipality.
अच्छा, not the municipality. Okay.
मुनिसिपैलिटी तभी देगा, मुनिसिपैलिटी कभी डेथ सर्टिफिकेट देगा तब उसका ज्यूरिसडिक्शन में मर गया, तो तभी मुनिसिपैलिटी देगा ना कि ये बंदा मेरा ज्यूरिसडिक्शन में मर गया.
Naturally, either in the home or in the hospital.
Either in the house, hospital, road, या मर्डर हुआ, कहीं किधर भी मर्डर हुआ, उधर एरिया का म्युनिसिपैलिटी देगा. अब ये बंदा का तो पता ही नहीं ना मिसिंग किधर हुआ ये.
Yes.
Then the court will give.
Now we see the may presume. It is a condition when the court enjoys the discretion power to presume any certain or few facts and recognize either proved or may ask for the corroborative evidence to confirm or reconfirm the presumption set by the court in its discretion. Section 4 of the Indian Evidence Act provides that a fact or a group of facts may be regarded as approved until and unless they are disproved. Okay. The concept is defined under the Section 4 of this Act that may presume deals with the rebuttable presumption and is not a branch of jurisprudence. Unless it is not rebutted, then we can say may presume.
No, this is obligatory on the part of the court.
Okay.
May presume. It is an obligatory part of the court.
Okay,
we are presuming it. We are not saying it is 100%.
Yeah.
We are taking on the face value. चलो ठीक है हम मान लेते हैं. लेकिन जब हम बोलते हैं हम मान लेते हैं, लेकिन कल के दिन वो मान लेते भी गलत हो सकता है.
But you have to rebut it and you have to prove it.
Yes. You have to prove it. Yes, sir. अगर इनकम टैक्स बोलेगा सर इनके पास बहुत पैसा है, इन्होंने मतलब ठीक है कितना पैसा है इनके पास, बोलता 100 करोड़ रुपए है, ठीक है आप बोल रहे 100 करोड़ रुपए, ठीक है हम भी मानते हैं 100 करोड़ रुपए। अभी किसको प्रूव करना है कि इनकम टैक्स को प्रूव करना है कि भाई इसके पास सही में 100 करोड़ रुपए आए बोल के?
Yeah. Because a
हाँ,
person who made such a statement has to prove it.
यस।
Suppose if you could fail to prove it, the other person can file a case against the person in the defamation.
नॉर्मली इसमें डिफेमेशन नहीं होता है।
Okay.
He can, he first of all he'll try to come out from that only.
Okay.
ये मुसीबत से निकल गया वही काफी, अब सोचेगा वो
Naturally,
defamation कैसे करेगा।
naturally. Otherwise, no. See, the point is, it is not proved over there. He came out of a danger. That's enough.
हाँ, नहीं तो हर कोई सरकार के खिलाफ डिफेमेशन सूट फाइल करते जाएगा फिर हर केस में।
Yeah. Huh? And moreover, the income tax people also will not make such an allegation without having the proof.
हाँ, इसमें क्या होता है, अगर इनकम टैक्स हो कोई भी हो, 100 करोड़ नहीं होगा, लेकिन
Yeah.
कुछ नहीं तो 10-15-20 करोड़ तो होगा उसका
Yes,
घोटाला।
yes. Though not 100, at least 20%, 20 or 30.
हाँ, फिर कोर्ट क्या फटकारा देता है इनकम टैक्स को, पुलिस को, कोई भी हो।
Okay.
पहले तुम देखने का ना, पहले 100 करोड़ बोलने से पहले क्या है, तुम 100 करोड़ बोल के 10 करोड़ में आ
Unless
गया
you
तुम।
harass that person.
हाँ,
Okay. Shall presume. It denotes a strong assertion or intention to determine any fact. Section 4 of Indian Evidence Act explains the principle of shall presume that the court does not have any discretionary power in the course of presumption of shall presume. Rather, the court has presumed facts or group of facts as regard them as if they are proved. Shall presume means as if they are proved unless until the other party will disprove it.
yes.
Is it
Now
not?
this
वही बता
is नहीं, इसमें क्या होता है, whenever we use the word shall presume or shall, which
Yeah.
means this is
Mandatory.
mandatory part.
Yeah.
क्या होता है
Unless other
whenever,
party dispute it.
हाँ, अभी इसमें क्या होता है, शेल प्रिज्यूम मैंडेटरी में प्रिज्यूम में क्या है, प्रोसिक्यूशन को प्रूव करना पड़ता है।
Okay.
शेल में क्या होता है कि मेरे को प्रूव करना पड़ता है, भाई प्रोसिक्यूशन गलत दिया मेरे खिलाफ बोल के,
Okay.
बिकॉज मेरे खिलाफ सब डॉक्यूमेंट्स है, मैं 100 करोड़ का घोटाला किया है, इनकम टैक्स वाला 100 करोड़ का घोटाला पूरा डॉक्यूमेंट्स लेके रख दिया कोर्ट के सामने, ये देखो इसने इधर घोटाला इधर किया, वो क्या होता है, इट इज प्रूव दैट इट इज मैंडेटरी, मतलब ये बंदा सही में किया है। नो, आई हैव टू प्रूव एज अक्यूज, आई हैव टू प्रूव कि भाई ये नहीं है। द
Yeah, breaking up the voices there.
from the
Yeah.
prosecution it comes to the shell में क्या होता है, the burden of proof shift from the prosecution to the respondent or accused,
Yes.
but in may presume the burden
Yeah.
doesn't shift to the accused or respondent, the burdens will remain with the
Person who
prosecution
makes
only.
such a statement.
Statement.
Yeah.
Yes.
Section 4 of the Indian Evidence Act explains that the concept shall presume may also be called presumption of law, or artificial presumption, or obligatory presumption, or
Obligatory
rebuttable presumption of law. So, rebuttable presumption of
Well,
law
actually,
is unless until the other party will rebut it. So, rebuttable presumption of law, and that tells that it is a branch of jurisprudence that is shall presume.
I don't know ये किसने लिखा, लेकिन ये obligatory presumption गलत लिखा उसने।
Is it?
It is not obligatory. May is obligatory and shall is mandatory.
Okay. I think this is improper way. Okay. Okay, let me presume it. So, can you say the rebuttable presumption of law?
Rebuttable from the respondent side, okay, बोल सकते हैं इसको, but obligatory नहीं बोल सकते।
Yeah. But we can say the presumption of law.
Presumption of law तो वैसे भी बोल सकते, may में भी बोल सकते, shall में भी बोल सकते हैं इसको।
But shall may is a command over there.
Yes, it's a command.
Okay. Now
You see any you see any laws of IPC or CRPC.
Okay.
You will never see any word the court may give him 10 years, ऐसे नहीं रहेगा
Shall.
और the court shall बोल के लिख के रहेगा उधर.
Yes, because there is no loopholes, there are no loose words.
Yes. तो क्या होगा अगर मैं लिखेगा, अगर जज को किसी का शक्ल पसंद आएगा तो 2 साल बोलेगा, वही क्राइम को किसको पसंद आएगा तो 5 साल देगा. अरे क्राइम तो क्राइम वही है, सेम क्राइम है, मर्डर किया उधर भी मर्डर इधर भी मर्डर.
That's why Income Tax Act, Penal Code, they are strictly construed. No loose words.
Any law, they don't use loose words.
Or especially the criminal law and income tax law. So conclusive presumption and proofs. It can be considered as one of the strongest presumption a court may assume, but at the same time, the presumptions are not completely based on logic. Rather, court believes that such presumptions are for the welfare or upbringing of the society. With regard to the conclusive proof, the law has the absolute power and shall not allow any proof contrary to the presumption, which means if the fact presumed under the conclusive proof cannot be challenged, even if the presumption is challenged on the basis of the probative evidence. This is the strongest kind of all the existing presumptions, whereas Section 41, 112 and 113 of the Evidence Act, Section 82 of the Indian Penal Code are one of the most important provisions related to the irrebuttable form of the presumptions or conclusive presumptions.
Yes. इसमें क्या होता है कि अगर मान ले some incident happen,
okay,
उसके ऊपर पुलिस ने सर्च किया तो चाकू मिल गया.
yes,
उसमें वो बंदे का फिंगरप्रिंट्स मिल गया.
yes,
और फोरेंसिक लेबोरेटरी से रिपोर्ट मिला कि यही चाकू से इसका मर्डर हुआ है.
okay,
और खून भी वही है, इसका ही खून है.
okay.
So that is called conclusive proof. मतलब इसके अलावा आपके पास कुछ है ही नहीं तुम बोलने के लिए. भाई चाकू वही है, गांव भी वही है, डेप्थ भी वही चाकू से हुआ है, जितना डेप्थ है, कितना लेंथ, साइज, फिंगर इंप्रेशन, और चाकू के ऊपर जो खून पड़ा है, यही जो मरा उसका ही खून है. सो दिस ऑल कंक्लूसिव प्रूफ. मतलब ये पूरा पक्का सबूत है कि भाई यही आदमी ने खून किया है.
Yeah. So everything, not a single point which will go against the points over there. All points, like you said.
और लोगों ने कोई बोलेगा मैं भी देखा इसको खून करते हुए, तो वो that is a part of conclusive proof.
Okay, means the place where it has happened, found blood stains, DNA, and the forensic report, and fingerprints, and everything prove that he is a culprit and he is an accused, and he is a murderer. Is a conclusive presumption. It is there. So the general definition of the conclusive proof is a condition when one fact is established, then the other facts or conditions become conclusive proof of another as declared by the act. That means whatever the proof would be there that are showing only one point, that he has done the murder or he has done an offense. The court in its consideration shall regard all other facts to be proved. Only one fact of the case is proven without any reasonable doubt. So all facts are showing the same thing and without reasonable doubt. If the other facts are proved on the basis of the proving one fact, the court shall not allow any evidence contrary to other facts which are presumed as a conclusive proof. So when it is presumed as a conclusive proof, then any facts will not be considered at all. So illustration we have given here is A and B married on June 1st, and the husband left home to his work for 6 months later. He discovered that her wife is pregnant. How it would be? Before 3 months she is already conceived. And he divorced the wife and challenges that he is not liable for paying damages either to his wife or to his illegitimate son. And also explains that they never consumed his marriage as a jest. After one day of the marriage, he left his home for his work. But in this case, the court will conclusively presume that the son born out of his wife is legitimate because he was with his wife for at least one day and shall not allow any proof contrary to the conclusive proof, even if he provides a probative evidence. क्योंकि
लेकिन एक दिन में तो कोई बच्चा पैदा नहीं होता.
Premature delivery also be possible, they will say.
No, premature delivery will happen. That is very rare case. But if you look into law of evidence, minimum 280 days होना चाहिए बच्चा को from the day when you whatever you have sex, whatever you call it.
Yes.
280 days. That is a law.
Yeah.
अगर इससे पहले पैदा हुआ है, मतलब अगर मान ले आज शादी हुआ है, 1 जनवरी को शादी हुआ किसी का.
Yeah.
और मान ले 2nd or 3rd को उसका फर्स्ट नाइट है, जो भी वो बोलो.
Yeah.
From the day when he's having sex or love, whatever go. So the court counts 280 days for bacha to become.
Yeah.
नहीं तो it's illegal.
Yeah.
So I don't know how this one day shall not be allowed any proof contrary. अब मुझे पता नहीं क्या sentence लिखा है किसने ये.
See, actually the point here is no, they will see whether the consummation was there or not, number one. If the consummation will be there, it will be made very clear whether she conceives or not after the cycles are concerned. The cycle should be suspended.
But having this thing in one day, आज तक मैं तो कभी किसी history, I have not seen any medical juice.
I don't think that this will be acceptable. As
in one day नहीं होता कभी.
Yeah.
कभी one day vaccine कभी नहीं होता.
We don't know because it is there. 6 months will not be there. If okay, one day also be there. After the 9 months delivery was there, then we can presumption.
If both were staying for 2 months, 3 months, then I can understand.
And after the 9 months, after the conceiving period, 9 months or 7 months is the delivery is taken place, then the presumption is that he is the father of the child, unless until the DNA is proved.
Yes.
If they have the doubt, they can make it out DNA proved over there. If the DNA says no, he is not the son of your so and so, that means she has begotten the pregnancy with somebody else.
Some other person. The marriage also will be invalid.
Yes,
the
marriage also invalid.
Everything will be invalid.
Yes. But a person who slept with that a woman, after the 2 months, 3 months he married the same woman. If she delivered it, then naturally he will be the legitimate son of the.
Yes.
Because
people like in live-in relation, they don't get married. They stay together. They have babies. Those are legitimate sons only. Second wife.
And entitled for the even the inheritance.
Everything, all maintenance, ancestral property, father's property. If the father dies while in service, the second wife's son is also eligible for compensation and job.
Okay.
Things that.
So now let us see the relevancy of the fact. I believe that at any time it will be stopped because time is nearly up. But I don't know. Today Cisco Webex is kind enough extending the time.
But ये इतना अच्छा क्लास को अटेंड क्यों नहीं किया? मेरे को समझ में आता नहीं.
पिलिसी पिल्लनित्ते कुलम जड्डदी अंटे. If you give a girl with that, might be she's having some other thing.
No, I'm not saying only one girl, because उसमें तो 200 लोग हैं, सब लिंक पे ज्वाइन होते हैं. इधर लिंक पे क्यों ज्वाइन होते?
The point is no, they are not qualified.
अरे सुनने के लिए, नॉलेज के लिए कौन सा क्वालिफाइड है? मैं कैसे सुन रहा हूँ?
See, people who knows it, they know the value of a professor. And the time and tide and wait for none. They don't know the value of it. If you know it also, if you attend it, it will be a reminder to you and you will strong your foundation also. And I teach because I promise to teach. And whether the student is there or not doesn't matter. Because I don't want to break my promise. I want to be continue on my say.
Anyway, only one more day is left tomorrow.
Yes. Only that. What is there? Huh? So relevancy of facts. Doctrine of res gesta. The doctrine of res gesta is expressed under Section 6 of the Indian Evidence Act 1872 in the following words. Facts which though not in issue are so connected with the facts in issue so as to form a part of the same transaction are relevant whether they are occurred at the same time and a place are at different times and place. Very good. Either same place or time or a different time and place, but they are very connected to the relevancy, and then we can say register. The register was originally used by the Romans, which means to act done or actus. The most important principle of this doctrine is that all the facts must be described in the same transaction. Whereas the transaction means a group of facts which are so connected to each other that they can be considered as a single fact. In a layman's language, a transaction may be considered as a series of certain acts, and when all the actions are carried in the same situation at the same point of time, then such situation or condition is be called as the act of the same transaction. Circumstantial or indirect facts are also considered under the doctrine of register, as they are also forming part of the same transaction. To know more about the doctrine of register in brief, please refer to the, of course, he has made it. Is another indication he made it. Oh, the essence of the register. Number one, the statement made should not be an opinion and must be a statement. Number two, the statement should be made by the participants of the transaction. The third bullet, third point, the statement should have enough information to explain or be brief about the incident. The fourth point, the statement made by the person or the act of the person should be spontaneous and simultaneous to the main transaction. The four conditions would be fulfilled, then we can say it is from the same transaction and the doctrine of register will be applied. Illustration, let us see. If a person is dying of a poison and before dying he tells the name of the accused. If a person is about to die, as accused in front of him, holding a gun, and he asks for help. If an injured person is crying for help, these are all come under the same transaction. Is it not?
या एग्जाम्पल आपका जो होता है ना वो शॉप वाला था.
या
फैक्ट इन इश्यू.
या
शॉप तो उसका है.
यस.
शॉप जल गया. शाम को जाके वो जाके केरोसिन लेके आया, लेकिन उससे पहले जाके दुकान वाले पूछा केरोसिन लीटर कितना मिलता है तुम्हारे पास, कल मिलेगा क्या मेरे को, मैं कल कितने बजे आऊं. These are all connecting
with the same transaction.
Yes.
Okay. So there is another participant, Mohammed Saheb. This is the class of the law of evidence, but if you are interested, you can listen also. So now in Ratton versus Kuhn, the victim, the wife, called the police for the help as her husband was holding the gun and was about to kill her. But before the operator could get connected to the call and report the statement of the victim, the call disconnected. Later, the police found her dead body in her house, from where she called the police for help. Later, the police found that the time of the call and the time of the death was almost the same as to the call by the victim, comes under the principle of register. The call came at the same time, disconnected. Very near time after it, she was murdered. That means it shows the same transaction. Hence, the court found that the husband guilty of murder and quashed his reasoning that he shot accidentally without any intention. So they will quash it because when she called the police for the help, that means he is showing the gunpoint nozzle towards her. Only the point is she has to pull the trigger. Is it not? In Shukar versus State of UP, the victim tried to alarm the accused, will shoot him in a few minutes. On hearing the alarm, the witness almost reached the place of incident. However, the victim survived and the accused was charged under the 307. That is the punishment for the attempt to murder. Despite the circumstances in this case being hearsay evidence, But still, the court recognized the act in the same part of the transaction and explained it to be a case of Section 6 of the Indian Evidence Act. Therefore, the statement of the witnesses were admissible as it formed a part of the same transaction because he is the eyewitness. Is it not? We cannot say it's a hearsay evidence because he came and he found that that fellow is dead. Despite the circumstance in this case being a hearsay evidence, but the court recognized it because he reached to the victim and survived. The accuser was charged under 307. In Uttam Singh versus State of Madhya Pradesh, the child and the victim were sleeping together at the time of the incident, and he suddenly awakened due to the voice of the axe and screamed for help by taking the name of the accused. Just after the call for the help, his mother, sister, and other witnesses come there. The court found that the evidence to be admissible as the act of the child and the accused was the same part of the single transaction. Yes, because it is two together goes, and after hearing the other people also comes and witnesses, and their witnesses would not be said as a hearsay, but it is admissible as it is the same transaction. So that is means they are also eyewitnesses there. Of course, they came only after the incident is over. 2. Motive, preparation and conduct. Section 8 of the Indian Evidence Act talks about the importance and of the motive, preparation, conduct, within parentheses, previous and subsequent, in various cases. And it is well known fact that motive and preparations are among the first act before any conduct. Therefore, Section 8 explains the importance of the motive, preparation and conduct where there are no direct evidence and the facts are proven on the basis of the circumstantial. Merely a person having the motive without preparation is not amount to an offense unless until it will be executed. Am I right?
As per the Indian Penal Code, FIR normally is filed after the incident.
Okay.
Chahe chori ho, rape ho, murder ho, jo bhi ho. It's only filed after the incident happening.
Okay.
But only in case of dacoity and waging war against the state.
Okay.
Before the commission could happen, before the incident happen, police can file FIR. These are only two offenses where for preparation and for motive, FIR is conducted. FIR is registered. Only for these two offenses. Dacoity.
In the robbery, in the dacoity as the waging war against the state.
Yeah, not robbery. Dacoity. And dacoity is more than 5.
Okay.
Any person more than 5, it is called dacoity. And
with the arms, without the arms.
Dacoity means with arms, without arms. It is dacoity means everything is including the arms only.
Okay.
Dacoity means arms.
Either the crude form of the arm or the pistol or rifle or a sickle or crowbar.
Even a stick is also called an arm.
Okay.
Only for this dacoity and for wage.
Merely preparation is enough. Okay. So now motive, the general meaning of motive, a purpose.
He is involved. The FIR can be written against him. Only those two, dacoity and wage.
Yeah, because you made it clear. No, the two incidents. One is a dacoity, another is a waging war against the state, where the preparation is enough. Shall I proceed?
To prove the conduct of that person. Yes.
Motive. The general meaning of the motive, a purpose or objective to obtain something. The Supreme Court of India defined motive is something which induces or activates a person to make an intention and knowledge with respect to the awareness of the consequences of the act.
Yes.
And he knows the consequences and he having the intention and he is having the knowledge, then we can say he is having such a motive to do such an offense. The relevance of the motive under the act. As in a above discussion, we have already seen that motive is the main inducing force which induces a person to do some act. It is expressed that if the offense has been commenced voluntarily, then could be no possibility of the absence of motive. If the motive is there, then only the thing will be happen. Although it is very difficult to obtain the evidence of the motive, still evidence of the motive becomes very important in the case of circumstantial evidences. The Supreme Court in the reference of the motive said that if the witnesses of any case are trustworthy and have enough credibility, then the motive of any act done by the offender has no such importance. I repeat, the Supreme Court in the reference to the motive said, if the witnesses of any case are trustworthy and have enough credibility, then the motive of any act done by the offender has no such importance. That means with a good motive he did it, with a bad motive he did it. When the evidence is given by the trustworthy people is there, it is enough. The act itself is an offense. Is it?
Yes, yes.
Although the motive and intention are the same, there is a thin line of the difference between them. The intention is the pre-calculation or knowledge of ascertained consequences in the mind of the offender. I can say in other words, a series of intention or the result of the intention is motive. The repercussion of intention is the motive. The ulterior intention is motive. Am I right?
Correct, but I'm not 100% sure. Because how can you get motive?
See, motive will be achieved when there is no intention, there is no motive. Intention, series of intention which is culminated to a particular target is motive. So, the difference between them, the intention is the pre-calculation or knowledge of ascertained consequences. They know it, they are going to happen in the mind of the offender. In some cases, it is observed that sometimes motive behind the execution of a crime may be good and the intention is always a bad or guilt-oriented. See,
Yes,
motive is different and intention is different. For instance, in country where cow slaughtering is banned, if you stop a man for slaughtering the cow, your motive is good. But if it is allowed in the country where the slaughtering is not banned, at that instance, your motive is good, but the country did not ban the slaughtering of the cow. The reason is no. We should not cut even the goat or any other animal else. So, if it is such a law is there, then naturally one cannot stop it. That means one should not cut it. But if it is allowed there, at that time we cannot stop it. Even though your motive is good, but law allows it, then you have stopped him to do certain things. Then you will be the offender. So, sometimes motive is good, but the output is an offense. Suppose motive is bad, the output is naturally bad. Or sometimes motive is bad, then everything will be bad. So that was the thing which is there. It is observed that sometimes motive behind the execution of a crime may be good, but intention is always bad or guilt oriented. So intention is naturally
आज क्या हुआ आपके ऊपर? वेबएक्स बहुत मेहरबान है आपके ऊपर.
Yes, because they want to say, no, these people are very much debating, no, they should not suffer it. Let them continue. Let them continue it. I think sometimes, no, they will forget to stop it. And we can take the advantage of at least 15 minutes to 20 minutes. In Kundula Bala versus State of AP, Kandula, in the Kandula Bala versus
Kandula
State
Bala
of
versus
AP, the son-in-law before his marriage demanded a piece of land from the deceased. But after the marriage, the deceased refused to transfer the ownership of the property and expressed that he would give this property to his daughter. Such inferences of the father-in-law induced the accused in committing a crime, and sometime the crime commenced. The court observed that there is a strong motive with the accused of committing the crime, as the father-in-law refused to transfer the property in the accused's name. So meeting will be end by the 5 minutes. Naturally, see, when he promised to transfer on the son-in-law name, let him transfer it. Otherwise, he can say on the spot only, no, I will transfer on my daughter's name.
But killing is not a solution for that.
See, if he has such a mind, he does not do such a thing.
Best thing is that if he doesn't give, then divorce his daughter and get out, the matter closed.
See, people does it because they wrongly calculate it. And they don't know what is the consequences of it. And that is the reason when you are angry, don't take any decision. Be cool.
एक केस हुआ महाराष्ट्र में ऐसे ही.
Yes.
What happened is that एक आदमी को 2 बेटियां हैं.
Yes.
तो बड़े बेटी and he is well off person. तो बड़े बेटी का शादी हो गया है and the son-in-law, daughter-in-law they stay in some other place.
Okay.
फिर क्या हुआ, छोटे बेटी का शादी का गया.
Okay.
तो अब इसमें क्या प्रॉपर्टी, अब जब छोटी बेटी का शादी हो गई तो प्रॉपर्टी दोनों को आएगा.
Naturally.
लेकिन बड़ा दामाद का है कि साला पूरा प्रॉपर्टी मेरे को आने का है.
मार दिया साली को.
तो नहीं, ऐसे क्या किया उसने, जब उनका घर पे जब वेडिंग कार्ड देने आया है.
Yes.
और वापस वो लोग आ रहे हैं रास्ते में.
Yeah.
तो उनका एक्सीडेंट हो गया.
Okay.
तो एक्सीडेंट हो गया तो ससुर नहीं है ना, वो नहीं है, सास नहीं है और वो बेटी भी नहीं है. अभी पूरा हक किसको बन गया, पूरा बड़ा दामाद को पूरा प्रॉपर्टी मिल गया.
Okay.
जब पुलिस इन्वेस्टिगेट करना शुरू, समवन मेड अ कंप्लेंट, जब पुलिस स्टार्टेड इन्वेस्टिगेटिंग कि ऐसे कैसा हुआ ये, फिर दे स्टार्टेड लुकिंग इनटू द टेलीफोन कॉल्स. वो बीच में कितना लोगों को फोन आया गया वो रोड में. उस दिन का कितना फोन आया, उसका कनेक्शन किया, पता लग गया पूरा ये दामाद ने ऑलरेडी प्लान करके रखा है पूरा एक आदमी के साथ.
Naturally.
मेरा दामाद आया, मेरा ससुर आएगा, घर पे आएगा, काट देगा, तो ये टाइम को निकलेंगे वो लोग, तुम उनको एक्सीडेंट कर दे ताकि एक्सीडेंट जैसे दिखेगा.
Everything is tapped.
Everything is tapped. He is behind bars. No.
now he could not get anything.
No, बीवी भी छोड़ के चले गई, प्रॉपर्टी भी गया.
Disinherited hota na, because if you kill a person for getting the property, you will disinherited by that because the motive is bad, no. So the example which is given,
आधा मिल रहा था, आधे लेके गपचुप बैठने का था ना.
See, the people greedy जो रहता है, कभी भी you should keep in the mind, what is in your hand is your property. What is not in your hand is not your property.
वो बोलते हैं ना, वक्त से ज्यादा किस्मत से, क्या वक्त से आगे किस्मत से ज्यादा समथिंग जैसे ना, वो नहीं मिलता किसी को.
क्या फायदा? What is the life? You can enjoy the life at least whatever you have it with you, instead of keeping the other things in the to grab it and you to enjoy the life. No, that is not the way of life. You enjoy and let the other people will enjoy. You enjoy, you contribute the enjoyment to the other. You make them happy to the others. That is the life motive, and life should be passed in that style. Not me only, no, we only. That is the, not as third person singular, no, first person singular is a first person plural. We, not I. That's why our preamble also say we. Am I right?
Yes, yes.
So, but anytime it will be stopped over there, and let me continue. I will keep the asterisk mark over here, and today is the 23 and tomorrow is the last day. Let me see that how much we cover it. With that, I would like to stop it. So thank you very much, Asante Sana, and now I'll close it. Right.
Good night. Good night.
End of the meeting for all. End meeting.
भारत भाग्य विधाता
पंजाब सिंध गुजरात मराठा
द्राविड उत्कल बंगा
विंध्य हिमाचल यमुना गंगा
उच्छल जलधि तरंग
तव शुभ नाम जय तब शुभ आशीष मांगे गाहे तव जय गाथा
जन गण मंगल नायक जय हे
भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।